Today we are talking about the fact that nearly all modern so-called constitutional law is based on a myth. And the myth goes back to an 1803, a very famous opinion from Chief Justice John Marshall in the case Marbury versus Madison. Now, I did a show, I think it was last month, on how the Supreme Court isn't supposed to be as powerful as it is. And in response, almost everybody, well, not almost everybody, we regularly hear this on this and various issues. Oh, if it wasn't for John Marshall and the Supreme Court assuming for themselves the power that the judiciary is supreme in all matters or other issues. I heard sometime, actually yesterday, someone told me it was in the 1820s that John Marshall said that the Commerce Clause means anything and everything. Basically, a lot of people have the general view that something, at least if you believe in limited government under the Constitution, or if you just believe that the Constitution means what it originally meant and it isn't to be interpreted and twisted over time based on what the court thinks it should mean at the time until it changes its mind, then a lot of people just knee-jerk reaction look to 1803, Marbury versus Madison, and the Marshall Court. And then also people who love big government, who want to expand government, who want to have basically a judicial oligarchy, as Thomas Jefferson put it, where you have 9 unelected, unaccountable, politically connected lawyers making the decisions. They're the final rule on anything and everything. Those people love this myth about Marbury and Marbury versus Madison as well. So I'm going to talk about this, that Marshall supposedly invented this idea of judicial review, and that the case was also about judicial supremacy, which are actually two different things. So we're going to talk about both review and supremacy and why they're quite different, and the difference is very important. We're going to look at some of the texts from Marshall himself, including his views on the oath to the Constitution, which I think is really, really important. I might, if I have time, I'm going to get into Thomas Jefferson's views on the judiciary and on this, at least, how they almost tracked Marshall, and 4 main implications of rejecting the myth and how things are supposed to play out in Washington, D.C. Anyways, Marbury versus Madison, 1803, was a U.S. Supreme Court case that established the principle of judicial review in the United States. So this is the general understanding. Marbury versus Madison established judicial review. That's where it came from, out of thin air. Meaning that American courts have the power to strike down laws, statutes, some government actions that contravene the U.S. Constitution. Decided in 1803, Marbury remains the single most important decision in American constitutional law. This is, so whether you think Wikipedia is a reliable source or not, it is a reflection on what is extremely popular or widely accepted. So when you look up Marbury versus Madison on Google, this is the story that people are being told. It's the most important case ever, at least in constitutional law. Again, I put constitutional law in quotes because I think that's just a phrase that says that they're going to make law and it's kind of tied into the Constitution, but it's really not about the Constitution all the time. And then the other myth is that it established the principle of judicial review. We'll get into this a little bit further, but it's not just there. Here's the Library of Congress, loc.gov. From the government itself, the U.S. Supreme Court case of Marbury versus Madison established the principle of judicial review, the power of the federal courts to declare legislative and executive acts unconstitutional. The unanimous opinion was written by Chief Justice John Marshall. I don't know who wrote this. We have no idea. But this is an official government website from the U.S. federal government, from the Library of Congress, and they are taking the position that Marbury versus Madison established the principle of judicial review. Now, what is judicial review? Of course, I'm just going to give a brief definition of it from Cornell Law. This is the idea, according to them, fundamental to the U.S. system of government, that the actions of the executive and legislative branches of government are subject to review and possible invalidation by the judiciary. Now, that's kind of a moderate view of it. Basically, if there's a case in front of the Supreme Court, they're going to be able to take a position that either the executive or the legislative branches are doing something that violates the Constitution. But judicial review is often confused with judicial supremacy. And supremacy, I think, is far more problematic than anything that we're talking about facing. In fact, Suzanne's article, and Dave, their article that we just published on state sovereignty and the Fourth Amendment really covers this. Because the notion that a single group of people are going to make decisions for 50 sovereign states, as they put it, and 330 million people is ludicrous. In fact, many founders considered that idea dangerous. So judicial review and judicial supremacy are different. So here's the Washington Post. Decided in 1803, at the dawn of the new republic, Marbury versus Madison is the foundational case of American constitutional law. They're just repeating what we heard in Wikipedia. This is when I'm pulling up these links and I'm showing you these quotes, it's because it's just a good representation of what you're going to find all over the place. And it's not just in blogs or in Washington Post or the mouthpieces of the establishment. It's not just Library of Congress. This is the type of thing that is taught to lawyers or budding lawyers, wannabe lawyers, as they go through school. They're taught that the world starts and ends with Marbury versus Madison. Marbury versus Madison established judicial review, and that it also, they take the position that, quote, and this comes from Washington Post, but this is a very common view, it represents Chief Justice John Marshall's declaration that the Supreme Court possesses the ultimate power to interpret the Constitution and determine the legitimacy of acts of Congress. This goes almost unchallenged. This mentality that the Supreme Court, based on what Marshall had to say, is the ultimate power to tell us what the Constitution means until it changes its mind. And they use Marshall's words. Of course, we know that if you take things out of context, you can make it look like whatever you want. And that's maybe giving a tip of the hat or a kind of advanced notice of where I'm going with this, but it is certainly out of context. Marshall's famous words, it is emphatically the duty of the judicial department to say what the law is. And I think the greatest resource, well, there's a number of them that are actually very good. There's a book by William Watkins Jr. on judicial supremacy. But if you want a paper, it's going to be dozens of pages. If you want to do a lot of reading, we're getting into Michael Stokes Paulson, who wrote a number of years ago about judicial supremacy. But he also covered the fact that this isn't just being made up. The Supreme Court itself is taking this position. So not only are we seeing in Washington Post and Wikipedia, we also find that a Supreme Court opinion has put this into practice as well. This is Aaron versus Cooper, or Cooper versus Aaron. If I get the citation wrong, I apologize. But this was in 1958. They say they're referencing Marbury versus Madison. They're referencing that same quote. It is emphatically the province of and duty of the judicial department to say what the law is. And then the Supreme Court itself took that phrase on its own and said it means this. This decision declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution, and that principle has ever been respected by this court and the country as a permanent and indispensable feature of our constitutional system. To me, it sounds like an oligarchy. Lifetime appointed, unelected, unaccountable, politically connected lawyers. A permanent and indispensable feature. They tell us what the Constitution means. No one else. I mean, you're entitled to an opinion, but if the Supreme Court says your opinion is wrong, then your opinion is wrong. Not the other way around, of course. And that's the view. We have this infallible Supreme Court that even if it makes mistakes, it will fix them. It will tell us if it makes a mistake. The only way that the Supreme Court makes a mistake is if the Supreme Court says it makes a mistake and reverses an opinion maybe decades later, maybe never. And that's very problematic. So here's what Michael Stokes Paulsen had to say in this article, The Irrepressible Myth of Marbury. It's a PDF file from 2004. I've got it linked in the show notes at 10thamendmentcenter.com/goodmorningliberty. And I like how he puts this. Nearly all of American constitutional law today rests on a myth. The myth presented as standard history, both in junior high civic texts and in advanced law school courses on constitutional law, runs like this. So we're getting this in the general public. We're getting this in high school. We're getting people who are training to be lawyers, people who eventually become judges. They're all learning this from day one. And it goes like this. A long time ago, 1803, if the storyteller is trying to be precise, in the famous case of Marbury versus Madison, the Supreme Court of the United States created the doctrine of judicial review. And this is the power of the Supreme Court to decide the meaning of the Constitution and strike down laws that the court finds unconstitutional. And he goes on, as befits the name of the court from which the doctrine emanates, the Supreme Court power of judicial review, the power in Chief Justice Marshall's famous words in Marbury to say what the law is supreme. And if you're reading along, you can see that he highlights this. He puts it in italics, basically saying, look, the Supreme Court has an opinion. They're going to take an opinion on the constitutionality of acts of the executive or the legislative. And now it's expanded through the incorporation doctrine, which is his own episode, to acts of the states. And once the Supreme Court takes that position, that is the Constitution. In essence, the Constitution is only what the Supreme Court tells us it means. And Paulsen goes on, the Congress, the President, the states, indeed we the people who ordained and established the Constitution are all bound by the Supreme Court's pronouncements. Thus, the decisions of the Supreme Court become, in effect, part of the Constitution itself. Even the Supreme Court is bound by its own precedents, at least most of the time, in stare decisis. And I apologize again if I'm pronouncing that incorrectly. But basically, the Supreme Court is supreme over everybody. Not that it's just the top court in a system, but that it actually has supremacy in power and opinion. Again, this is a myth, and we're going to go through why this is a myth. This is an excellent article. I'm going to go back to it a few times in this episode. So T.J. Martinell did an overview of this. Again, the link is in the show notes of this particular article, and he starts out with this quote from Paulsen. Nearly every feature of the myth is wrong. Basically, everything they tell us about Marbury versus Madison is wrong. Both on the good side, that, the good guys that want to limit government get it wrong as well most of the time. And of course, the bad guys want to twist it into something that expands centralized power all the time. And Paulsen goes on, for openers, Marbury versus Madison did not create the concept of judicial review, but at least in this respect, applied well-established principles. Again, judicial review and judicial supremacy are different, and hopefully this distinction will come clear as I talk through this. The idea, he goes on, that the courts possess an independent and power to interpret the law, and in the course of doing so, must refuse to give effect to the acts of the legislature that contravene the Constitution, was well accepted by the time Marbury rolled around. This was well recognized in the courts of many states. So state courts were doing this all along. It was contemplated and debated by the framers of the Constitution. It was defended in ratification debates. And Alexander Hamilton, centralizing, king-loving, liberty-hating kind of guy, I don't know if he was necessarily liberty-hating, but his approach to trying to preserve liberty was bad. He also addressed this in Federalist number 78, and he says this, the interpretation of the laws is the proper and peculiar province of the courts. A constitution must be regarded by the judges as a fundamental law. It belongs to them to ascertain its meaning. But the important distinction, again, a case that comes before the Supreme Court, the Supreme Court issuing an opinion on the constitutionality of something, basically reviewing what's going on in other branches of the federal government in a case or controversy, and issuing their opinion on something, is far different than judicial supremacy. Judicial review is the issuance of an opinion. And in fact, the Supreme Court itself, when they have these so-called rulings or decisions, which they are not, at the top of it, it specifically says an opinion of the Supreme Court. And hopefully that shines a little light on it as well. An opinion is reviewing something and having an opinion on the constitutionality of something. And Paulson goes on to say that the power of judicial review was, quote, never understood by proponents and defenders of the Constitution as a power of judicial supremacy over the other branches, much less one of judicial exclusivity in constitutional interpretation. So the myth that we're sold is that Marshall created this idea of judicial review, and judicial review means that only the Supreme Court can say what the Constitution means. And when the Supreme Court says what the Constitution means, it's supreme over everybody else, and it's the only one that can have an opinion. So everyone just defers to the Supreme Court on everything. And that's how people approach things. And then when the Supreme Court has an opinion, people say, well, this case was decided. Why don't you go home and try to go vote some bums out so they can put in a different Supreme Court justice maybe in 2-3 decades, long after you're dead. And that's the approach that we get today. Going further to Paulson's article, again, focusing on judicial supremacy, he says, look, the logic of Marbury implies not, as it is so widely assumed today, judicial supremacy, but constitutional supremacy. If you actually read the opinion itself, if you read Marshall's words over and over, he refers to the Constitution as supreme. Not the courts, not the legislature, no one else. The Constitution is supreme. So people are twisting this into saying that the Supreme Court, in and of itself, its opinions are supreme. Paulson goes on saying, the supremacy of the document itself over misapplications of its dictates by any and all subordinate agencies created by it. And he goes on, under Marshall's reasoning and Hamilton's before him in Federalist 78, it's very similar. The duty and power of judicial review do not mean the judiciary is supreme over the Constitution. Rather, their duty to review things based on the Constitution exists because the Constitution is supreme. And we're going to tie that in to the oath as well. Marshall wrote this, the framers of the Constitution contemplated that instrument as a rule for the government of courts as well as of the legislature. So the judiciary isn't supreme over the Constitution, telling us, okay, this document now means this, and now it means that, now it didn't mean this. The Constitution is the rule above all of them. And that's what Marshall said specifically. Just don't want to lose my place here. I apologize. So this is distorting, according to Paulson, what they understood to be the power of judicial review, a coordinate, co-equal power of courts to judge for themselves. Again, they have an opinion. Every branch of government, everyone takes an oath to the Constitution, so everyone should try to defend the Constitution in the way that they understand it best, not just do what they're told. So many people take the position that it's the duty of the executive branch to merely enforce every law on the books to full effect. Well, I can think of a handful, maybe a few thousand, maybe a couple, maybe like 10,000, 20,000 federal acts or regulations on the books that violate the Constitution. So if you are a constitutionalist president, your duty is actually to not enforce federal acts that violate the Constitution. Your duty is to actually uphold the Constitution no matter what the other branches have to say. That is a constitutionalist. And the way this judicial supremacy thing plays out is, well, it's a passing of the buck. I kind of think this is unconstitutional, but it's not my job. I'm just going to keep enforcing this. I know that commerce doesn't mean all human interactions, but this is what the law says. Some other president in the past signed it. Some other Congress passed it, and a judiciary where a handful of people are dead, well, they said that this is constitutional. So I don't have a choice. I guess I'll just keep doing it until someone sues me, and then the Supreme Court can maybe overturn that based on who I pick. That's not how it's supposed to play out. It's a coordinate, co-equal power of the courts to judge for themselves the conformity of acts of the other two branches with the fundamental law of the Constitution, and to refuse to give acts contradicting the Constitution any force or effect insofar as application of the judicial power is concerned. So in other words, the judiciary, it's the duty of the judges to try to follow the Constitution and tell people that it is their view that acts that violate the Constitution should not be enforced. Now, there is no enforcement arm in the judiciary other than this public opinion that the federal judiciary is powerful over all of us. Going a little bit further here, let's look at this quote. It is emphatically the province and duty of the judicial department to say what the law is. Now, if you take it on its own, then you might get the opinion like they did in the Washington Post or the Supreme Court in 1958. I'm assuming they were just lying. That this means that it is only up to the Supreme Court. It is really just a repetition of what Hamilton said in Federalist 78, and neither of them actually claimed exclusivity or superiority of the federal courts. That's somebody actually having to twist it for their own goals. And Paulson puts it this way: more often neglected is the immediately following sentences from the same paragraph of Marbury. Of course, if you take the one sentence out of context and you don't read everything after it, then you're going to be pushed in the wrong direction. He says, which explain why it is the province of the courts to say what the law is. Quote, those who apply the rule to particular cases must of necessity expound and interpret the rule. If two laws conflict with each other, basically an act of Congress, a statute, versus the text of the Constitution, the legal meaning of the Constitution, the courts must decide on the operation of each. So basically, the notion that Marshall was presented with, that the court was presented with, was this statute versus the Constitution. Now, maybe Marshall got everything wrong in Marbury constitutionally, but what he didn't get wrong was this idea that they should look to the Constitution. Some people actually wanted them only to look at the statute and not have an opinion on constitutionality at all. And Paulson is very clear. This approach, basically having an opinion on constitutionality, is a far cry from judicial supremacy because it has no enforcement. No one is required to follow that opinion. And that's the whole idea of co-equal branches bashing it out with each other. They may think differently. They may decide that they should go a different direction. He goes on. Oh, and he says, it basically, what I was saying. This is a statement when performing judicial tasks calling for deciding whether an act of Congress departs from the Constitution, that the courts are up to the task. They have to look to the Constitution. It is a huge and illogical stretch, one certainly not warranted by the emphatically the province sentence, and indeed quite inconsistent with the rest of Marshall's argument, to move from the proposition that the courts are competent to determine constitutional cases to the proposition that the court's views bind everyone else. And that's where judicial review has been twisted into judicial supremacy. Basically, an edict of the Supreme Court, or an opinion of the Supreme Court, is turned into an edict. It's turned into law. But Supreme Court opinions, Supreme Court doesn't make law. They just have opinions on what has been passed at law. And we also know that any act of the legislature outside of the Constitution is void. And of course, many founders said this very early on. Theophilus Parsons in the Massachusetts Ratifying Convention, Madison and Jefferson. Of course, James Otis Jr. many years ago said this, but John Marshall also said this in Marbury versus Madison. And he actually just took the position that it was up to the Supreme Court to say that it was unconstitutional, but it doesn't bind everyone else. Of course, if you think something is unconstitutional and you want no one else to do it, you want the end result that no one else does it, but it isn't binding on them. You have to convince them. And of course, I keep mentioning the oath, and hopefully I've got this. He talks about the oath to support the Constitution. Everyone, all the judges take an oath to the Constitution. They don't take an oath to party. They don't take an oath to various principles or goals. Their only oath is to the Constitution. And immediately after stating that the Constitution is, quote, a rule for the government of courts as well as the legislature, Marshall asked this: why otherwise does it direct the judges to take an oath to support it? This oath certainly applies in an especial manner to their conduct in their official character. If you're taking an oath to the Constitution, then your job is to defend the Constitution, no matter what anybody else has to say. How immoral to impose it on them, Marshall writes, if they were to be used as the instruments and the knowing instruments for violating what they swear to support. In other words, Marshall is responding to the notion that he should just not look at the Constitution, not call something unconstitutional when he sees it that way. He says, why does a judge swear to discharge his duties agreeably to the Constitution of the United States if that Constitution forms no rule for his government, if it is closed upon him and cannot be inspected by him? If such be the real state of things, this is worse than solemn mockery. To prescribe or to take this oath becomes equally a crime. Again, the huge difference is having an opinion on the constitutionality of something versus being supreme and binding on everyone else in that particular opinion. And Paulson puts it this way: the implication of Marshall's argument from the oath requirement is obvious. Marbury is no argument for judicial supremacy in constitutional interpretation. It is an argument for the personal constitutional responsibility of all who swear an oath to support the Constitution to resist and refuse support to usurpations or violations of that Constitution by all others. Even if you stand alone, if you take an oath to do something, the only right choice is to follow the oath. And the founders, now maybe an oath doesn't mean a lot these days to a lot of people. Clearly, people in Washington, D.C., that has been pretty obvious. They don't really hold to this oath very well. Or they don't even know what they're taking an oath to. But I don't think many of them are trustworthy. But in the Founders' Day, an oath was serious business. Like serious, eternal business. You don't violate an oath. And so it is your duty when you take that oath to defend the Constitution, even in a room of 100 people. If 99 people say their view is different, if you really believe they're all wrong, you still stand up for what's right, for what you took an oath to do. And so Marbury, in this case, they're basically saying, look, it is our oath to defend the Constitution. We're presented with a case, a controversy between these two parties. We're going to tell you our opinion on it. I guess do with it what you will, but it is our opinion. This whole article is extremely interesting. It's a few dozen pages. I hope you take some time to read in it. Again, this is not just my language here, but it really gets into Marshall's opinion as well. Now, this is also from a different, I think this is from William Watkins Jr. a couple years later. And he points out that Thomas Jefferson, James Madison, many others, none of them criticized. The opponents did not write anything really in criticism of Marshall's opinion. And that should be taken very seriously, because if what happened was judicial supremacy invented out of thin air, Thomas Jefferson, who is a vehement opponent of such a thing for his entire career, would have written something about it. and he wrote nothing about it. Madison himself wrote nothing about it. Well, Jefferson wrote a little bit about the case, but nothing about this notion that the Supreme Court is their opinions have a legal force and impact on every other branch of government. I think, at least from my reading of this, based on Jefferson's actions, his inaction in response, the fact that no one really wrote against it at the time, Madison himself, who was part of that case, didn't come out and say, look, you guys made something up that we never discussed at the convention or in the ratification debates. This was widely understood that the courts would actually issue opinions, and no one understood those opinions as being binding on everyone else and being the exclusive opinion on the Constitution. No one understood it that way, because if it was understood that way in the court, if it was understood that way, we know Jefferson and Madison would have had something to say about it. That is a pretty strong probability. And Watkins put it this way: the fact that Jefferson and fellow Republicans failed to criticize the court's discussion of judicial review is a strong indicator that there was little or no disagreement on this third point of the opinion, that, of course, they're going to issue an opinion on constitutionality. And Jefferson's theory of constitutional interpretation actually is in line with this. He wrote a letter to Abigail Adams in September of 1804 talking about how he refused to continue the enforcement of the Sedition Act after he took office, and that he pardoned people that John Adams had put in prison or his administration had punished or convicted of violating. So he pardoned them, and he wrote to Mrs. Adams saying, look, nothing in the Constitution has given the judges a right to decide for the executive more than the executive to decide for them on the constitutionality of the Sedition Act. So basically, he's saying it's his duty under his oath to the Constitution, just like John Marshall said, his duty under his oath to the Constitution to act based on his view of the Constitution. Now, when you're voting bums out, which never seems to work as an aside, you just get more bums. Of course, you want to vote in the people who have the right view of the Constitution or something in line with you. But to say that they don't have a duty to actually resist usurpations of the Constitution is absurd. It does not fit with what Jefferson or Marshall had to say, or Madison. And he believed, and he put it this way, although he believed that the Sedition Act was unconstitutional, he conceded that, and this is in Jefferson's words, the judges, believing the law constitutional, had a right to pass a sentence of fine and imprisonment because the power was placed in their hands by the Constitution. Likewise, the executive, believing the law to be unconstitutional, was bound to remit the execution of it. So this is how it's supposed to play out. This is the branches checking each other. The Congress passes something. A president signs it. It goes to court. The Supreme Court says, this is our view on the Constitution. Someone is going to get an imprisonment or a fine. This is going to be your punishment. In response, a future president says, that's not constitutional. I will not enforce this, and I'm going to pardon the people that you punished for this. Think how this would play out on things like prohibition of guns or drugs, plants, things like that, milk, whatever it may be. And Jefferson put it this way: that instrument meant that its coordinate branches should be checks on each other, but the opinion which gives to judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislature and executive also in their spheres, would make the judiciary a despotic branch. It's basically the power of a king, if it can do that. And no one was making the case that it could do this. Jefferson was clarifying, look, I know this was, me and your husband had some debates, but I respectfully want to explain to you why I did what I did. And it's because it's my duty under my oath to not enforce things that I believe to be a violation of the Constitution, even if the Supreme Court has a different perspective. Again, this is a kind of a departmental theory of the Constitution, which I agree with. There are four main implications of this. Four main implications of how this means things are supposed to play out. That means not only do we have judicial review, but we should have executive review. That means the Under the oath to the Constitution, everyone has a duty to defend the Constitution as they believe it is supposed to be in effect, not defer to another branch of government. So 4 main implications of the myth of Marbury versus Madison establishing judicial supremacy, which is not supposed to exist, is that not only should the judiciary issue an opinion, we should also have the executive having their own opinion and acting on it. This is what Thomas Jefferson did, for example. We should also have congressional review of the Constitution, taking actions based in their own sphere on their own view of the Constitution. And then we also have, I think this is even more important, the unconstitutionality of stare decisis, or the requirement of going to precedent. Now, if the Constitution is supreme, then precedent means nothing if the precedent goes against the Constitution. Unfortunately, this principle, this theory, is held higher than the text of the Constitution itself. And then fourth, and I think very importantly as well, is the principles of state interposition and nullification. And this is how Paulson put it in his article. He says, "It follows, I submit, that state government officials who likewise swear an oath to support the U.S. Constitution as supreme law of the land are not bound to submit docilely to unconstitutional actions of the agencies of the national government. By the logic of Marbury versus Madison, they cannot be bound by the erroneous constitutional views of organs of the national government, but are empowered, even required, to interpret the Constitution directly." Everyone who takes an oath, and that's really, I think, the big takeaway. Everyone who takes an oath have a duty to that Constitution, not to the opinions of other people in government. Because no one in government, at least under the American constitutional system, is supposed to be supreme over everybody else. We, the people of the several states, are sovereign, and sovereigns have delegated some powers. They did not give up that sovereignty. They can take those powers back. But in the structure of these co-equal branches, and I would say 4 of them really, if you count the states, they all take their view, and that's how you create this kind of pushback from branch to branch, by not having anyone be supreme over everyone else. Looking over at the chat, wow, lots of really great stuff going on here. Sabalytic says, "I believe the Constitution is a blueprint for how government is to protect liberty and how power is to be limited in doing so. It's a rule of delegated powers, saying what the federal government can do, and some areas restrictions on the states." Holly Carter, I think, gets it absolutely. "It always amazed me that a single court ruling, quote, decided constitutional law. Seems like the Constitution decided constitutional law, but hey, I'm just a citizen who can read plain English." And in fact, part of the understanding of the founders opposing this idea that the judiciary is supreme over everything is the fact that under the British system, Parliament was sovereign. The king was sovereign. So Parliament, if they said something, it was just up to them. They decided for themselves. And we know that Jefferson and Madison told us that if the federal government could ever determine the extent of its own authority, that power would always grow. You don't give an institution the power to determine its own power. And being part of the federal government, the judiciary was never given that power. Jason Carricos says, "The jury alone is the ultimate arbiter of all laws, not just the Constitution." Interesting. Dan Reed, "So from my plebeian view, all opinions which follow this case are flawed." Well, if they follow the actual words, Dan, of the opinion itself, basically that it's the duty of the court to actually issue an opinion, then yeah, that's fine. And of course, they should have an opinion. You and I probably have an opinion on what's constitutional, what's not. Maybe we're right, maybe we're wrong, but that's what the court was saying. What the big myth is that what the court says is law and part of the Constitution. It's in effect amending the Constitution if it gets it wrong, and that everyone is bound to that. David Smith, "I loved history and civics class in school. This is like a college course." Thanks for the shout out. I don't know about, I'm doing my best. And Holly Carter, absolutely correct. Judicial review is a big stretch from judicial supremacy. It's the court issuing their opinion on a particular case. And in fact, if you heard me earlier, that Marshall actually said a specific, how he wrote it, case in front of them, of course. EHP training, of course, great reminder over on YouTube to smash that like button. Thank you very much. Eric Nance said the Constitution clearly gave a negative power to the president, so they understood negative powers. If they wanted the Supreme Court to have that power, they would have said so. But it doesn't say that. It does not say that the Supreme Court, the federal courts in any way, have a veto power over the other branches. They have a power to look at something, issue their opinion, and act in their own sphere based on that opinion. And like Jefferson said, so do the other branches. In fact, that's their duty. That's what Marshall, Jefferson, and everybody else, that's what I'm saying too, that if you take an oath to something, it is your duty to follow that oath, even if everybody else says you're wrong. Holly Carter again. Wow, Holly, you're rocking it today. Justin Bayola. Again, here's the hammer hitting the nail squarely. The oaths no longer mean anything. Yes, they, of course. Well, they're counting on us relying on this view that the Supreme Court writes laws, they legislate, they amend the Constitution. This oligarchy. Jefferson warned that it was an oligarchy, and I put it up on our Twitter account this morning. Let me see if I can pull up this quote here. He says this: you seem to consider the federal judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine. And he goes on that in this same quote to say, if you take this position, you leave us in a place of an oligarchy. And he was absolutely correct. Andrew Nappy, good to see you, buddy. Certainly there is not a word in the Constitution which has given that power to them more than to the executive or legislative branches. Jefferson in 1815. That is very similar to what Jefferson has said many times. I don't know that quote off the top of my head. Andrew, if you're still watching and if you got a link to it or at least a reference to what letter that was from, I would love to have that as well. Teacher of Liberty, Joe Wolverton, says, and he had texted me a quote on this earlier, and I think I really need, Joe, I don't know if you want to write an article on this, it would be awesome. Jefferson's views on judicial supremacy coming from his various letters, whether to Abigail Adams, to Spencer Roane in 1819, like you texted me earlier. And he's saying, look, this is all coming from the same place as well. And he says, mind you, I had no idea you were talking about this today. Nick Hankoff. State legislature should be able to appoint justices and pack the SCOTUS for the benefit of the 10th Amendment. Make it happen, Bolton. Oh, yeah. Eugene Carroll, Marbury versus Madison is a ridiculous case to base law on. Marbury screwed up and was later appointed Chief Justice and then tried to get Madison to carry out Marbury's screwed up, and Madison refused and told him where to go. That's an interesting interpretation of it. What we do know about Marbury versus Madison is that what we're told about Marbury versus Madison has been a lie. The Supreme Court is not supreme beyond being the top court in that particular system. Maybe they should have called it the primary court. I don't know. It is not supreme in power, effect, and law. We are not bound to obey them. The bottom line is if they make a law, if they have an opinion on a law, if they sign something, issue a regulation, act, treaty, order, whatever it may be that is outside the Constitution, you are not bound to obey them. And it is your duty, especially if you take an oath to the Constitution, to refuse to give it impact and effect. That's Jefferson's view. I believe that was Marshall's view as well. He said this as well. This is his duty under his oath. Anyways, I hope you guys found this really interesting. I know we're going a little bit long on this. Nappy says, this is Brian McClanahan. Oh, again, we're getting a lot of references to Brian's awesome books, Founding Fathers Guide to the Constitution, page 138. Thank you so much, Andrew. That is a great book if you guys are looking for something to read. So I hope you guys found this interesting and educational. I hope it wasn't too long and rambly. This is a very kind of deep, complex issue to cover. Same with some of the other things that I've covered recently on the Commerce Clause, necessary and proper, and others. I'll have a short edition. We always do a Fast Friday edition where the episodes are somewhere around 10 to 15 minutes on Fridays. So if you want something quick and easy, that will happen on Friday. I'm not sure the topic yet. I hope you guys have an awesome day. If you support the show, make sure to smash the like, hit subscribe, get bell notifications. And of course, if you want to pitch in a few bucks a month, 10thamendmentcenter.com/members. Do not feel obligated. I'm going to continue providing as much content and education and updates as possible for free. And for those of you who think we're doing a good job, a great way is to tip us a couple of bucks a month, 10thamendmentcenter.com/members. Again, thanks so much for watching. I really appreciate you spending some time with me today, and you guys have an awesome day today. We'll see you next time here at Good Morning Liberty.